Hello, testing, testing. This is me, Sukhdev, and this is my first attempt at doing a live on the Ween page. Hello, good morning. Friday mornings at 10 with Sukhdev Sran. I'm Sukhdev Sran, and this is my first attempt at doing live on the Ween page. So just let's have more of our friends join us this morning. Hi, good morning, Kanti. How are you? Thank you for joining. Thank you so much. Thank you for your support. Let's just wait for a few more of our viewers and then we can start with today's topic. So a little bit about today's topic, that is on wills and estate administration. There's been a lot of emphasis, recently on the need to have a will and the importance of having a will. Okay, so I have always been writing and encouraging for our general public's benefit on why making a will has become so important, especially during this pandemic. Okay, so we'll just wait for a few more minutes for more of our audiences to join in so that they can have the benefit of today's live, okay, today's discussion. Thank you so much for joining in. There are 7 viewers at the moment. Thank you so much. Please encourage more of your friends to join in so they too can benefit, right? Okay, so let's have an interactive session. Maybe you can tell me about how are we coping with the current pandemic? How's business getting on? How's your health? How are things getting on for you? It's a bit tough because restrictions are limited on movements, right? We have to comply with the SOP. But yeah, what to do? We have to take care of ourselves. We have to stay safe, right? And at the same time, we have to have a balance in order to also earn a living. Okay, so right, let's share with encourage more of your friends to join us. Say hello for all the viewers who are here. Give me some indication, and we shall go. I shall start on the session um, shortly. Hello, good morning. Welcome to Friday mornings at 10 with Sukhdev Sran. Okay, it's sharp 10 o'clock and I will start the session. For those who have not joined in or are unable to join in, I will save this video so that you are able to view this at your leisure hours. Hello, Susila. Thank you for joining. Thank you so much. Okay, so introducing myself, I am Sukhdev Sran. I'm an advocate and solicitor of the High Court of Malaya. I'm practicing at Kuala Lumpur. Some of you all may already know about my legal firm, Law Chambers of Sukhdev, and my newsletter, The Legal Buzz. Okay, so today is the first episode that I am giving voice to the legal buzz, and I've been writing about issues for the public awareness. And today I'll kickstart to speak about the legal issues that I've written about. Okay, so my presentation is general advice for the public to be aware of your legal rights, all right? And if there's anyone who needs any legal advice, then please feel free to consult, and I'll will give you the advice that you are seeking for. Okay, so for the presentation purpose, this is a general advice and it is not to be construed as a legal advice. Okay, right. So now we all know what a will is. Okay, it's basically a document that consists of the list of our assets. The list of our assets, will contain things that are, for example, your bank accounts, the monies that you maintain in your bank accounts, the investments that you make. Some of us do unit trust investments. There are also the properties that we own. Okay, for example, if you have one or two houses, condos, even apartments, all right, and perhaps also your jewelry, all right. So all of these things will need to be distributed to your beneficiaries. Okay, now when will the will take effect? Good morning, Vigneswari. Thank you for joining. Okay, so when will the will take effect? The will take effect upon our death, right? So, for example, upon my death, then my children can give effect to the will, all right? So, because of the assets that I have, I will use myself as an example. Okay, so because of the assets that I have, and I wish for my children to benefit from them, so I need to then list in my will how I am going to distribute my assets to my children. All right. So that is what the purpose of the will is. It's a document that will list your list of assets, your list of beneficiaries, and who is going to benefit from each of the property. All right. The will can also contain your instructions on who is going to be the legal guardian and trustee for your minor children. Those, if you have children below the age of 18, you need someone to take care of your children, to be able to use the funds in order to, educate your children, and then perhaps the balance of the remaining funds after they have graduated, to be distributed to them. So it's entirely up to you as to how you want to word the will and who is to benefit from your assets. You can even leave instructions like, I wish for a certain amount of money, or a particular property to be given to a charity. You can even name the charity if you want to. So there's no restriction, okay, as to how you wish to go about doing this. All right. So that's the purpose of the will. Okay, I would just like to try and share with you the legal buzz that I have previously prepared. Okay, let's see, how do I share document? Hold on, yeah. If you have any questions, then you can always feel free to type in the comments column and I will try to answer each of your questions. Okay, I'm not so sure how to share the document, but basically, I have prepared this document on why has having a will become so important. It's my Legal Buzz newsletter and it's dated the 28th of February 2021. So perhaps you could look up this document. I will try to repost it again for your benefit. Okay, so now that you know why what the will contains, all right. the most important message is that a will conveys the wishes of the testator. Okay, the testator is the person who's making the will. So my will, I'm the testator, and I wish to convey on how my assets are to be distributed and taken care of after my death. All right. Okay. Now, what happens if there's no will? Right. Now, if there is no will, then uh, what will happen is that the assets will have to be distributed according to the Distribution Act. Okay, so upon my death, my husband and my two children will not automatically inherit, okay, my property. It will be based on the Distribution Act, and this will also include my surviving parents. Okay, so there is the manner of distribution is based on the Distribution Act. So you'll have to include the parents if you have surviving parents, or if you're a bachelor or an unmarried woman, okay, then you know your siblings, your parents, okay, whoever is surviving, right? Then the percentage of the distribution will be based on what's listed in the Section 6 of the Distribution Act. Okay, I'll just answer this one question here. Vigneswari Sadasivam, can a will writing seed life insurance nomination? Okay, the simple answer is no. Right now, I said that in the will you will list out your assets. Now there are some organizations, for example, EPF, insurance, certain unit trust investments. All right, this will require you to register your beneficiary. All right. Now, you will have to go to these organizations, all right, go to EPF and register your beneficiaries, right? Now, what will happen is that if you don't register your beneficiaries, then the distribution of the proceeds from your EPF, from your insurance, will be distributed according to the Distribution Act. You cannot name your beneficiary to receive your life insurance proceeds or the EPF proceeds in your will. It will not be as per your will because these organizations require you to register your beneficiaries. So for that reason, the answer to your question, weakness, is no. Hello, Mekwan. Thank you for joining in. Okay, so now when there is no will, the difficulty is not only that the distribution will be according to the Distribution Act, but the process will take much longer. Okay, there will be this two-stage process where the first thing that needs to be done is to appoint an administrator, right? But in the will, you can already name who you want to be the administrator, okay? To apply for the grant of probate and then distribute the property as is written in the will. So when there is no will, then somebody will have to apply to be the administrator, apply for the grant of letters of administration from the court, okay? And upon obtaining the letter of administration, then they will have to register that grant of LA at the land office for each of the properties. Okay, so if, for example, someone has 5 properties, then it has to be registered at 5. Now, before the registration, of course, you need to apply for the certified true copies of the LA. You just can't go with the LA like that. It has to be certified true copies from the High Court, okay, and then go and register. So that's stage 1 taken care of. And then you start with stage 2. Now, stage 2 is where you apply for the distribution. So you have got to name all your beneficiaries. Sorry, not your beneficiaries. You have to name all the beneficiaries to the estate of the deceased person. Okay, so whether there's a surviving spouse, surviving parents, children, and get the appropriate order from the court regarding the distribution. Okay, it may be that parents may give up their rights to the properties to be inherited by the children or the surviving spouse. So all that will have to be made known in the affidavit. All right, and then the court will grant the order accordingly. Okay, now once that order is granted, only then you are able to file or sign all the appropriate documents, okay, in order to give effect to the transfer of the property from the deceased person to the beneficiary. So basically, the role of the administrator is to step into the shoes of the deceased person to enable the administrator to sign on behalf of the deceased person, to give effect to the transfer of the property, to make withdrawals from the bank accounts, any other investment units that does not require registration of beneficiaries, so that the estate, the accumulative assets of the deceased person can be distributed to all the living beneficiaries. Okay, thank you, Witness. Thank you for the question. All right. So now, when there is a will, then you don't have to go through the two-stage process. All right. So that the whole idea of being able to transfer the property to the beneficiaries is cut short. All right, and it saves time, money. Now, with the pandemic, matters at the land office, takes a little longer than necessary because of the SOPs, the appointment dates that we have to apply for, the backlog that this pandemic has created. Okay, so why do you want something that can be done in a shorter period of time take so much more longer and become more expensive? All right. Hello, Meikwan. Hello, Revati. Thanks for tagging June. Please share with more of your friends so that they can benefit from today's presentation. I will be saving this presentation so that more viewers can have the benefit and be able to raise their questions so that they all get their answers. Okay, so now that we already know what happens if there's no will and the two-stage process, let me just share with you what are the details and documents that you're required to make a will. Very easy. Firstly, obviously your name and your IC number and your current residing address. Then the name and IC number of the person who you wish to appoint as the executor for a male person or an executrix, a female person. Now, basically, the executor and the executrix are the persons who will be the administrator of your estate. Okay, so upon the death of the testator, this administrator will take the will and go and see a lawyer, right, to apply for the grant of probate. Now, depending on the values of the value of the assets, right, certain applications for the probate can be made at Amanah Raya or even at the land office and at the High Court, all right? But the High Court, the Civil High Court, has got the overall jurisdiction for granting the grant of probate, all right? So you can actually just go and see a lawyer and make the application for the grant of probate with the will. Now, coming back to the contents of the will, list of assets, right? Your movable properties, which is, your bank accounts, your unit trust investments that does not require beneficiaries to be registered, maybe your car, your motorbike, your lorry, your van, all your immovable properties, which are your apartment, your houses, your condos, state it correctly. All right. Now, if you only own 50% of a house, then only 50% of your share can be distributed. Right. So you must make sure that these assets are properly registered in your name. Right. Because what does not belong to you cannot be distributed. So do not assume that you own a full share of the house. Be certain of the percentage that of the house that you own. For example, husband and wife may co-jointly own 50% each of a house, right? So in that case, you can only distribute 50% of your share, all right, and not 100%. Right. List of beneficiaries. Who do you want to inherit your properties? So give their full name and IC numbers. All right. Instructions on how you want the estate to be distributed. All right. For example, elder son to get this house, second daughter to get that property, jewelry to be divided equally amongst all the daughters or all the children. It's entirely up to you. All right. But state it very clearly. And most importantly is also instructions on residue estate. Residue estate is, for example, if you inherit something from your parents, for example, okay, or from your siblings, something that you did not expect. And it has, and you have inherited it. So you want that now to be distributed to your beneficiaries. So you can also leave. Say, if I do receive or inherit residue estates, then I wish for my children to have equal distribution of the same. A simple one sentence, all right? Now, coming back to the naming a person to be your administrator, it is always advisable to name someone else in the alternative. Why? This is because the first named person, if he or she is not able to apply for the grant of probate and take over the duties of the distribution, all right? For example, if the person has passed away or the person is ill, all right, or maybe away from the country, then there is an alternative person who is able to give effect to the will. All right. So basically, these two persons are people who you trust will be able to carry out the instructions that you have left. All right, in the will. And now, for the manner of the distribution of the estates, I would also advise that you name someone in the alternative. Okay. Now, for example, the house in Kajang is to be inherited by my eldest son. In the event that he predeceases before me, then the house in Kajang is to be inherited by his children in equal proportion. Something like that. Okay? So you have somebody in the alternative to inherit. All right? Okay. Now, the last portion of the will is where the testator, that means you who is making the will sign, and in the presence of two witnesses. Now, what is the need for the two witnesses? The Hello, Harwinton. Thank you for joining. Okay, so the two witnesses here, they are important because when the administrator is applying for the grant of probate, the witnesses will be required to sign an affidavit affirming to the validity of the will. Okay, so they're going to say something that's very simple in their affidavit to say that, yes, they have witnessed the testator signing the will, and this is the last will of the testator. All right. So that will minimize, the dispute on the validity of the will. Now, I'm not saying that just because there's two witnesses, nobody else can challenge the will. All right. There are cases where the will still be challenged, if there are grounds to do so. But basically, the role of the witnesses, two witnesses, the role of the witnesses is that. All right. Now, there are certain circumstances where, perhaps one witness has passed away. All right. Then the administrator will have to try and get a copy of the death certificate of that witness and include it into, into the document to the court to say that, look, one witness has passed away and this is the death certificate. Then the surviving witness can always affirm to the validity of the will. All right. Okay. So you have made the will, you have stated everything nicely, all right. You have even given instructions regarding, legal guardian and trustee of your children and how you want your um, estate to be distributed. Now, let's say after 10 years, your children are now all grown up. They no longer require legal guardian and trustee. So what do? Make a new will. All right. You can make a new will. You can change the contents of the will. Maybe the list of your assets too would have, increased, change. You would have sold one house or bought another and things like that. So when there are these changes, you can always make a new will. You do not have to worry about what's going to happen to the first will that you did. Okay, for example, you made a will in 2021, and let's say in 2029, you have decided to change your will. The very first sentence in your will, okay, in the will document states that this is the last will and it will automatically revoke any will that is made prior hereto. All right. So the will that you will make in the year 2029 will be the last will that you made prior to death, and any other wills that you have made before 2029 are automatically revoked. Okay, so the will that you make in 2021 will not stand anymore. Okay, it just has no effect. All right, so you can change your the contents of your will in time to come. All right, and the same procedure, you must make sure you have two witnesses, name your administrator, you can always change your administrator too. You don't have to stick to the same person whom you have earlier nominated. All right. So you can do that. Okay. Now, when you have already made your will, then what do you do with the will? You have to make sure that you keep it in, a safe place. You don't want it to fall into the wrong hands. Sometimes dispute just arises out of that. All right. Be very careful with the will. At least let your administrators know where the will can be found. All right. And of course, all these are spoken in confidence. Okay, it's not something that you will publicly announce unless you want to. That's your choice. All right. Good morning, Caroline. Thank you for joining. Thank you so much. If you have any questions, please type in the comment section and I will try to answer your questions. All right. And yeah, so keep your will in a safe place. Now, whether there is a will or there is no will, when the administrator applies for the grant from the court, okay, I'll rephrase that. When there is a will and the administrator applies for the grant of probate from the court, the administrator will have to submit the original will and the death certificate to court. Okay, so the court will keep that. The original will not be returned. So there will be a photocopy of the will that will be attached to the grant of probate. All right, so that you still have a copy. It will be certified by the court as a true copy. Now, when there is no will, so the administrator will apply for the grant of letters of administration. So it's LA, right? And together with the LA, the administrator will have to submit, the death certificate. It will be kept by court. So together with the grant of LA, the death certificate, the list of assets, the list of beneficiaries will all be will all form one document, okay, stapled together, so that later when you want to give effect, to collect that money from the bank or go and register at the land office, then the whole set will be certified by the as true copy by the High Court, and then you can go ahead and do whatever is necessary. Okay. Now I actually wish to show you a sample of the grants of LA so that you know what it looks like, or even the grants of probate. But I do not know how to share. I'm so sorry. I did see the share screen earlier, but I just can't see it now. So hold on, just let me see whether I can share. Hmm. Well, maybe if you get in touch with me, then I can show you what it looks like. I'm very sorry that I will learn this. I promise you in my next session, when I speak about the next legal issue, I will learn how to share documents on FB Live. Okay? Right. So, with that, we have spoken about the making of the will, right? What do you do with it? What are the court processes? How the distribution takes place? What if there is no will, right? How is the distribution? Now, let me share with you some tips that I have also shared on my legal firm Facebook page, right? The first tip is apply for 2 copies of the death certificate from JPN. Why? Because one copy will be given to court and you can always retain the other copy. The second tip is now the immovable and movable property. So basically the list of assets of the deceased person is not automatically inherited by the next of kin or the beneficiary. So all of us, most of us, we've got this thought, that, oh, when someone passes away, the beneficiary will automatically inherit. No, it doesn't happen that way. Okay, when there is a will, the beneficiary is named in the will. All right, so yes, the beneficiary will inherit provided there is no challenge by anyone else. Okay, now there are procedures to be followed. Only then the beneficiary at the end of the day will inherit. So it's not automatic. Okay, you cannot run to the bank or the land office and say, look, this is the will of the person, and this is the death certificate, so please transfer to the beneficiary. It doesn't work like that. Okay, so there's no automatic transmission transfer. It must go through a procedure and process. All right, so if there is no will, then the procedure is the 2-stage processes. It will take longer compared to if there is a will. All right, tip number 3. The person to be appointed as the legal guardian for a child of a minor age can be named in the will. So I've already explained to you, right? The importance of having someone to be appointed as your legal guardian, as the legal guardian of your children, your minor children, someone who you are able to trust to raise your children, okay, in your absence, upon death, that is, right? And now, what if you have not named anyone in the will to be the legal guardian and the trustee? And if any of your family members don't come forward to take that responsibility, then what happens? So the answer lies with the court. The court will appoint someone to be the legal guardian and trustee. So at the end of the day, the choice is yours whether you want to name someone who you trust, to be the legal guardian of your child or children, and trustee to use your funds to make sure that your children are educated, or whatever instructions you give in the. It will provide some form of certainty for the children, knowing that their mother and their father have actually cared and left instructions for their growing up and well-being after they have passed on. Okay, right. The testator will require 2 or more witnesses when signing the will. So this has already been explained. Okay, and the 5th one is what I always try to emphasize and bring about the awareness, is that it is prudent that the living spouse or children, as the next of kin of a deceased person without a will, should apply for the letter of administration without delay. Okay, so now just let me explain to you 2 things here. One is the 2-stage process when there is no will, which I've already explained in detail. And the other thing is the delay. All right, should there be a delay? Now, um, you see, when there is a will, uh, the application for the grant of probate should be made as soon as possible and within 3 years. Any application that is made more than 3 years or after 3 years will need to provide an explanation, okay, to the satisfaction of the court as to why the delays in applying for the grant of probate. Similarly, for the grant of LA, okay, if it is made after 3 years, then the court will want to know why did you delay. Okay, now last year I had a client who came forward to apply for the grant of LA for the assets of her deceased father, and this application was made approximately after 7 years. So the question is why? The court wanted to know why, because she didn't know the process. She was not aware that she needed to um, apply for the LA in order to inherit the father's assets. But the court accepted. Okay. Now there's another thing. When there's no will, okay, and to apply for the grant of LA, and if the total assets is more than 50,000, then the administrator will have to provide two sureties. Sureties are persons who act as guarantors to ensure that the administrator complies with the requirements of the law in respect of the distribution of the estate. Now, in this pandemic era, or even ordinarily, is it going to be easy to look for two persons to stand in as sureties? I don't think so. I don't think anyone is, going to say that, all right, I'll take that responsibility. Okay. So for, when the administrator applying for the grant of LA, uh, at that stage, we also put in an application to the court to seek for the court's, um, you know, uh, inherent jurisdiction to um, dismiss with the requirement of the two sureties. All right. Now with this pandemic, so it's difficult to find, and it all depends on the court. If they insist that that you must comply with the law, then you have to provide with that two sureties. So if you don't want the next of kin to have this one issue, because without complying with this, the administrator is not going to get the grant of LA, then make your will. Making a will save a lot of hassle for your next of kin, who are basically your surviving spouse, your children, your surviving parents. Okay, it will make a lot of things easier. The whole process is shorter and faster, and so that they can continue living. All right, they can continue with their lives, and they'll be very, very grateful, that at least, um, you know, the certainty and the assurance that you have always been there to provide them can continue. All right. So that's um, that's one important consideration as well, in making a will. All right, so think about it. Now, a lot of people are also under this thought, that, oh, if I make a will today, I'm going to die tomorrow. It doesn't happen that way. Okay, making a will not kill you, but this pandemic may, if we don't stay safe. All right, we don't stay safe, and if we don't follow the SOP, and we don't take care of the needs of our family and our dear ones, our loved ones, the pandemic can kill us. The will not kill us. All right. Okay. Good morning, Jay Shiva. Good morning, Sangeeta Dines. Good morning, Kalista. Thank you so much for joining in. Okay, there is a question here by Rita Sharma. If there is will, can one still challenge to change the beneficiary? Yes, that can be. That can be a challenge, all right, to the will. But if a beneficiary is challenging the will, all right, then there must be reasons. You cannot just simply say, "Oh, I want to challenge because my name has been left out." There must be reasons to support the challenge. All right. So on one hand, the will is, a savior for the surviving family, but at the same time, there can also be a challenge if anybody who has been left out or not named as beneficiary in the will wishes to challenge the will. All right. So yes, that can happen too. Now, this is a very important message that I want to give out to all our Malaysians, that the making of the will, the presentation today applies to non-Muslims, all right? Because our Muslims friends have got their separate Sharia principles to abide with, okay? And for the non-Muslims, all right, we are required to register our civil marriage. All right. So, for non-Muslims, this is mandatory. All right. According to the act. All right. Hold on now. The Law Reform Marriage and Divorce Act, okay, has made it mandatory that marriages of non-Muslims must be registered. Now, why am I emphasizing on this? It's not only the whole grandness in attending the ROM, the registration of marriage date and all that, but the marriage certificate plays a very, very, very important role to prove that you are the spouse, the surviving spouse of the deceased person. Okay. And the second thing is that the children to the marriage are the legal beneficiaries. Okay. So without the marriage certificate, if the marriage is not registered, the children are considered as illegitimate children and they cannot benefit unless there is a will. So if the parent, either the mother or the father, has prepared a will and said that, okay, my three children will inherit, my partner, who is supposedly the husband, okay, is not named in the will, he cannot challenge because there's no marriage certificate. He cannot prove that he's the husband, although he's the father of the three children. Okay, the three children are considered to be the illegitimate children because the marriage was not registered. All right. Then the next argument will come about that, oh, we had the ceremony, the religious ceremony in the temples, in the gurdwaras. That's not going to stand because it is mandatory, and I repeat again, it is mandatory that civil marriages of non-Muslim citizens of Malaysia must register your marriages. Okay, then automatically your children are legitimate. Even if there is no will, they will stand to inherit through the Distribution Act. Okay, so that's one important message to our fellow audience. Make sure that you have got your marriage certificate with you and make a will too. Okay. Now, the other message that I gave out in my last week's uh, presentation, I was invited by J Warriors Training Academy to speak on wills as well. Okay. The one important message that I gave out there is that for housewives, all right, if you are not a working mother, you're a housewife, and you think that you do not own anything, you do not have anything, so you do not need to make a will, all that is a misconception. At the very least, you have your children to think about. Okay, you can always make a will and leave instructions on how to care for your children. They'll be very, very grateful to you. All right, so anybody can make a will. You do not need to own bungalows and five houses and 10 cars, and millions in your bank accounts or investments before you think about making a will. We are all appreciative of whatever we have, and with that it suffices to make a will, because basically the very important thing about the will, it conveys your wish on how life is to be continued by your surviving family, all right, and how you are continuing to care for them. So the only document that can give effect to your wishes after death is through the will. Okay, so that is, the very basic importance of having a will. Now with this pandemic, with the Delta variant, we can't even leave the house. Um, you know, the new normal is getting to each and every one of us. We are having, mental health issues. Some of us are depressed. Many of us have raised the white flag, and many of us are also helping each other with, daily needs, whilst taking care of ourselves, right? So uh, all that is meeting our needs yesterday, today, and tomorrow. But the reality of the pandemic is we do not know who the virus is going to hit next. So before it is too late, okay, and before anyone regrets, please take time, okay, take a pen, take a pencil, sit down and start sketching out your will, and then meet a lawyer and get your will done. All right, it's not expensive now if you get your will done, but if you don't get your will done, then it will be even more expensive for your surviving family. All right, so okay, I think I have explained, and spoken all there is about the will, and what happens when there is no will, the court processes, what needs to be done. If there are any questions, please type them in the comment chat box so that I can address your concerns. Any questions? I would like to read out to you. I would like to share. This is a real life comment that I received from one of my friends on Facebook. Okay. Now, this is the comment that she wrote out. Okay. Many people do not realize the importance of making a will. I hope all of you who haven't made one will watch this live session. Thank you. My late husband insisted on both of us doing one 4 months before he passed away. When he spoke of it, I cried because I had this negative attitude towards wills. But he was adamant and we made one. It made everything a lot easier to deal with later. You see, reality, yeah? So then she goes on to say, my youngest brother passed away suddenly a few years ago. He did not have a will, and neither did he have a nominee for his EPF. Okay. There was a lot of hassle to go through to settle his matters. There you go. So her advice is please make a will. Okay. Now this is a reality. This is real. Making a will is no joke. Not having one is, a very difficult. You place your loved ones in a very difficult situation. Okay, sometimes one situation is like this: having a surviving spouse, surviving children, and then surviving parents. And then there's always this for some, not all, for some they've got this feud between mother-in-law, daughter-in-law. Then the daughter-in-law will still have to approach the mother-in-law, or the son-in-law and mother-in-law. The son-in-law still has to approach the mother-in-law when there's no will. Okay, ordinarily they don't speak. Then after the after, and in this situation, then they have to approach each other, and that takes time. Okay, so if you want to eliminate all these issues, just make a will. All right, it'll save a lot. Okay, Rita Sharma, how much does it cost to get a will? Estimate. Okay, now as a lawyer, and since this is a general public advice, all right, I will not be able to openly announce how much it costs to make a will. But what I can tell you is that there are organizations such as Rock Wills, okay, who have got their own cost, okay. Some will take a certain percentage of the total assets. Legal firms, they too will charge a certain amount. It depends on the complete complexity, okay, of the will. A simple will, sometimes, for others who their assets are a bit more complicated, then it will vary accordingly. So I'm sorry, Rita Sharma, because I cannot state openly what um, the figure would be to cost to get a will. Otherwise, this whole presentation will turn into an advertisement. I can get into trouble for that. So maybe if you can get in touch with me later, then I can explain to you how much it costs. Okay. Hi, Amajit Sran. Thank you so much for joining. For all you viewers, I think you all know Amajit Sran. She's the famous Amajit Kitchen. She does her chapatis and all, and she's my sister. So some of you all already know her. Okay. Now, in the very beginning last year, I had done this community series where I did a series of 5 videos, and Amajit Sran's video was the very first one where we kickstart the series, uh, where the first part of the presentation was to promote their business, because it was the start of the pandemic and all. And the second part of the presentation was where they get to ask me a question. So I have this 5 presentations, which was done over the month of November and December. I think I started in October, right up to 31st of December. These videos are available on my YouTube channel, okay, the YouTube channel of Law Chambers of Sukhdev. Please feel free to go through those 5 videos, because some of the issues that I've raised here and some of the questions that you all have asked have all been covered in those 5 videos. So you can get a better info, further knowledge, right, and further understanding by watching that videos as well. All right. Thank you, Rita Sharma. Thank you for understanding. So yeah, we are 48 minutes since it started. Thank you so much for the questions. Okay. Yes, Amajit Sran, I will put the link here on this site after the video, after this presentation is over. Please do share, with your friends and family, all right, so that they can have, first-hand knowledge on the importance of writing a will. Everybody is promoting it, so do take the time and the effort to get your will done. Okay. Now, something about Friday mornings with Sukhdev Sran. Friday mornings at 10 with Sukhdev Sran. This is actually my effort to give voice to the newsletters that I have been writing. My newsletter is The Legal Buzz. So I intend to discuss one legal issue at every presentation. Okay. The presentation for next week, and I hope that it will materialize and be really, really good for everybody, okay, is consumer rights. So, we have been reading a lot of a lot of comments from sellers and buyers, on the several Facebook page, right? Some of the difficulties, that we experience, regarding the goods, regarding delivery, regarding sellers' rights, consumers' rights. So I'll try to address these concerns and discuss it with you, hopefully next Friday. Okay. Yes, Amajit Sran, making a will now is something that's very valuable. Agreed. Okay. So, any more questions? Have you all found the session to be valuable? Give me some indication, please. Can I have some feedback regarding the presentation today? Okay, so with that, I will end my presentation for today. Thank you, Amajit Sran. Thank you. She says, yes, it's a good session. Thank you so much. Okay, so with that, I will end today's presentation. Thank you so much for all my viewers for today. Thank you for watching in. Thank you for the questions. Thank you for the encouragement. And I hope to be able to provide you all with more issues to be discussed in weeks to come. All right. And do feel free to text me, if you have any queries that you wish to ask on a personal basis, right? I will answer your questions. All right. Yes, Rita Sharma, thank you so much for the questions and the encouragement. So with that, ladies and gentlemen, thank you so much. Have a good Friday. Stay safe. We all have to think of ourselves first and also to think of our community. Let us all strive to be a pandemic survivor. Okay, so with that, good day and bye.